Good evening, everyone. My name is Antonia Wunderlich, and on behalf of the British-German Association, it is a pleasure to welcome you to this online event. For those of you who are joining us for the first time today, the British-German Association is a charity and membership organisation that promotes mutual understanding and good relations between the UK and Germany. Part of what we do is to provide a vibrant forum for debates, talks, discussions, and learning about Germany and British-German relations. So we regularly put on events such as this one, along with other initiatives such as our monthly newsletter. We are honoured to have with us today Professor Ulrich Kelber, the Federal Commissioner for Data Protection and Freedom of Information, and Dr. Nora Nielsen, Senior Lecturer in Law and Director of the Information Law and Policy Centre at the University of London's Institute of Advanced Legal Studies. Professor Kelber will start by sharing some opening remarks on international data transfers and related key developments in data protection law, and then there will be a wider discussion moderated by Dr. Litzon. The last 10-15 minutes will be devoted to an audience Q&A session, and the Q&A will be conducted via the Q&A function, which you should be able to find at the bottom of your Zoom screen. So if you click on it, you can start typing up and sending in questions. And please do so over the course of the event and we'll address them at the end. You can also like someone else's question, and the more likes a question gets, the higher up it is on the list. Without further ado, I would like to hand over to Professor Kelber.
Ladies and gentlemen, dear Antonia, dear Nora, good evening from my side, from the city of Bonn. And despite the current sad and disturbing circumstances, I'm pleased to be able to exchange opinions with you today, amongst others on the subject of international data transfers. As we all know, data transfers do not stop at borders. As a result of the digitalization of all economic and social sectors, personal data are increasingly transferred and processed globally within a framework of digital services and business models. As this significantly affects personal data, the question arises how these data can be effectively protected during their journey through different countries with different legal traditions and thus also different data protection laws. Data protection is therefore no longer a mere national or European issue, but a global one. The withdrawal of the United Kingdom from the European Union illustrates this fact, where recently a single judicial area to which the United Kingdom belonged was still enforced, the European Union with the GDPR. National laws now apply, and from an EU perspective, the UK is a so-called third country. It was therefore necessary to put data transfers between the EU and the UK on a new legal basis, which was realized by the European Commission's adequacy decisions of June 2021. This example illustrates the importance of working internationally to achieve a uniform understanding of the protection of fundamental rights, and thus also uniform data protection standards. The GDPR is a set of rules with a spillover effect beyond the European Union. This is shown by the international developments in Japan and Brazil, where new data protection laws have been adopted and where the GDPR was taken as a blueprint. Korea has also moved closer to European law, while Mexico, India, South Africa, and even some US states are on a similar path. However, the GDPR is not only a model for national data protection laws throughout the world, a practical application also extends beyond the borders of the EU and the EEA. On the one hand, this is achieved through the so-called market location or targeting principle in Article 3, which applies to data processing by controllers not established in the European Union. And on the other hand, this is realized through the instruments for transfers to third countries under Chapter 5 of the GDPR, in particular by means of the European Commission's adequacy decisions, but also through other transfer instruments referred to in Article 46, such as standard contractual clauses. Even before leaving the European Union, Great Britain has already implemented the GDPR into its own national law and thus incorporated the level of protection provided by the GDPR. And I very much hope, and please forgive me to being so frank, that the level of data protection will continue to be equivalent to that of the European Union, and that the UK government will not shake these foundations. Unfortunately, some of the comments made by the British Digital Minister last year give me serious doubts. The consequences would be disastrous for both sides. In this context, I'm entirely convinced that a high level of data protection comparable to the GDPR does not necessarily means to be an obstacle for the British government pursuing the aim of developing global partnerships quickly and creatively in order to make it easier for British companies to exchange data with important markets and fast-growing national economies. It's important that the level of data protection in these partnerships reach a corresponding level comparable to that of the GDPR. In a globally interconnected world, there must be a free, secure, and trustworthy data flow, regardless of the differences in national and regional jurisdictions. Otherwise, trust in digital transformation, digital services, and business models will be lost or will not emerge in the first place. This is why we're also working beyond the European level with international data protection supervisory authorities in order to achieve a high level of protection. However, it's primarily the responsibility of national governments to create the necessary international legal basis. In this context, there are important impulses above all from the OECD and the G7 countries, which are debated under the heading Data Free Flow with Trust. At this point, I would like you to give a brief overview on the international committees in which we work, mostly together with our colleagues from the United Kingdom. This happens, for example, within the framework of the Global Privacy Assembly. The GPA sees itself as a priority forum for data protection supervisory authorities from all over the world, more than 130 of us, for the purpose of exchanging experiences and for joint consultation on important globally relevant issues. To this end, the GPA can adopt resolutions. The program of the last annual conference once again demonstrated the importance of international data transfers in this forum. Several program items were dedicated to this topic. This involved, for example, transfer tools from different regions of the world. But quite different approaches to solutions have also been addressed. For example, the Council of Europe Convention 108 Plus, updated a few years ago and functioning as the first and only genuine international agreement on data protection rights so far. In addition, since last year, there's also been an exchange within the newly founded G7 group, which includes the data protection supervisory authorities of the G7 countries. The ICO is also represented, the British colleagues at this roundtable, and my office works well, closely, and gladly with the colleagues from UK. The so-called G7 roundtable of data protection authorities was also launched by the British side. September last year by my former British colleague Elizabeth Denham in the context of the G7 presidency of the United Kingdom. As part of this roundtable, we have agreed on closer cooperation between G7 data protection authorities in the digital age. The first meeting of the group took place under the lead topic, Data Free Flow with Trust. In that meeting, it became clear that technological developments, innovations, and increasingly significant international data transfers must go hand in hand with compliance with high data protection standards. For this purpose, we do not only need cross-cutting regulatory approaches between data protection authorities and other authorities such as competition and antitrust authorities. Above all, we need an understanding from the perspective of fundamental rights protection of the extent to which accesses by security authorities to data in global communication networks are to be tolerated. In this context, data subject rights must always play an important role because people and the economy's trust in new technologies and the global digital economy depend on these rights. The result of the first G7 roundtables was summarized in a communique, which is available on the ICO's and my website. This year, Germany has taken over the G7 presidency. The G7 data protection authorities exchange started last year, will continue this year as a part of the official G7 program. I'm pleased to be given the chance to bring forward this exchange in my capacity as chairman. The topic data-free flow with trust remains a central concern, which is to be supplemented by the ideas of creating so-called data spaces. I'm strongly advocating that personal data can be freely exchanged between companies and institutions in democratically governed states of the world, in accordance with the respectively applicable international rules, in order to enable economic prosperity, promote scientific exchange, and also in order to create a countermodel to China, Russia, and co. So the national level of protection does not to be the same if compliance with the respective essential rules of the game is ensured. But what needs to be adapted is the protection of citizens from disproportionate government access. This can be no free and trustworthy flow of data between countries if the citizens' legal protection is not guaranteed. From a European point of view, states with an Anglo-Saxon background must take a step towards a more global rule of law. In the context of international data spaces, for example, in the area of health data, existing data should be shared and used, provided that a high level of data protection is guaranteed, which is uniform with the space. However, this can only be achieved by means of harmonized rules based on safe and globally recognized transfer tools, focusing on the protection of personality and data subject rights. Such data spaces can be a basis for valuable and future-oriented cooperation, also for new innovation, not limited by borders, like the Gaia-X project, funded and supported by the federal government in Germany. In all these efforts, our European regulatory framework, the GDPR, can and should set as standards and have a role model effect on other legal systems in third countries from our perspective. So why don't we promote that we already have and what is considered a quality feature? For example, taking a basis of the GDPR, transfer instruments developed within the European Union, such as code of conduct, certification schemes, that could set standards worldwide and have an impact beyond the European Economic Area. We should aspire and aim at being actively involved in the shaping process. And exactly at this point, I see the similarities with the plans of the British government and those of my British colleagues. It's my objective to discuss these approaches for global transfer tools at the G7 roundtable in September with my international partners, and to make a joint contribution to the debate on high international legal standards and uniform secure data spaces. In this context, we recognize that the degree of bindingness of recommendations and resolutions by international committees is certainly lower than binding EU or international law. Nevertheless, this should not prevent us from continuing intensively the exchange and cooperate at international level. Therefore, we need a globally harmonized understanding of technologies, of legal standards and administrative praxis, even if the path to it will be lengthy, painstaking, due to different traditions and standards. And here I assume that my British colleagues share this view. I just want to make a short detour before I get to the United Kingdom's data protection law from a USP perspective. The Schrems II judgment of the ECJ, July 2020, made us aware of problems and risks for international data transfer. International data flows are accessed, in particular by intelligence services and other security authorities. Here, as I've just said, there must be a clear and preferably internationally harmonized limits that had been criticized by the European Data Protection Board, also in opinions on the European Commission's adequacy decisions on the United Kingdom, also with regard to existing United Kingdom security laws. The conclusion with the European data protection authorities and the Commission drew from the judgment is that an adequate level of data protection does not exist in a third country when the access rights of the security authorities are disproportionate. This proportionate design of such access rights, including sufficient rights and legal remedies for data subjects, must therefore become objective for global data transfer. In Chapter 5, the GDPR provides a wide range of tools transfers to a third country that allow data transfers without any specific authorization. provided that they comply with the requirements of the ECJ and the Schrems II judgment. These tools include adequacy decisions, standard data protection clauses, certification, codes of conduct, binding corporate rules, but also administrative arrangement. All these transfer tools can be set worldwide standards. From the point of the European data protection supervisory authorities, I should therefore be our concern to promote these transfer tools at international level. Following the Brexit, the United Kingdom is now also a third country within the meaning of Chapter 5 of the GDPR. So in June 2022, 2 adequacy decisions for the United Kingdom were adopted by the European Commission. Both decisions attest, building among others on the current British data protection laws, that the United Kingdom has an essentially equivalent level of protection to that guaranteed under European law. On this basis, international data transfers to the United Kingdom can take place without the requirement of separate authorization. However, almost a year ago, the European Data Protection Board gave a very critical follow-up to that procedure. I would like to pick out only a few points from that EDPB opinion of April 2021 on the adequacy decisions having regard to the General Data Protection Regulation. The EDPB has noted, among other things, that will be on one of the Commission's most important tasks to monitor the development of the British legal systems in the field of data protection as a whole, because, as briefly mentioned, the announcements by the UK government saying that it's intended to develop a separate and independent data protection policy, which could potentially deviate from EU data protection law, have already cast their shadows, and in advance when the adequacy decision were adopted. The EDPB has requested the Commission to carry out this monitoring. Deviations that pose a risk to maintaining the confirmed adequate level of data protection for personal data transferred from the EU would then have consequences. Moreover, the announcements made by the UK government are also a reason why the adequacy decisions provide for a 4-year sunset clause. Also ends in June 2025. Until now, adequacy decisions have not generally been accompanied by such a clause. In my view, the UK would use significantly more than it can win if it amended its data protection law in such a way that the adequacy decisions would not be extended. The EDPB has pointed out that it's concerned about the exchange of information and disclosure on the basis of other instruments, such as international agreements which the United Kingdom has concluded with other third countries, the UK-US Cloud Act agreement and the UK-US Communication Intelligence Agreement. Such arrangements or agreements can circumvent the introduced safeguard measures, and this is particularly difficult where, as in the latter example, the arrangement is not public. It could well be said that in the context it's an adequacy decision on probation. In addition, the EDPB has has called for further clarification, evaluation concerning bulk queries, in particular with regard to the selection application of selectors, because it's an unresolved question when access to personal data reaches the threshold set by the European Court decision and what safeguards are provided for in order to protect the fundamental rights of individuals. So the EDPB has asked the European Commission to closely monitor these developments. I will therefore remain to be seen whether UK will maintain this appropriate level or of data protection currently in place. Let us please call on the British government, as on the governments on the European side, to promote a global agreement between democratically governed countries and not to compromise the free flow of data with the European Union. So shifting from a bilateral thing to a global one among the democratically governed countries in that world. So we should consider the digital transformation, global networking, and associated international data exchange as a great opportunity. As a computer scientist from profession, I cannot do otherwise than seeing it this way. But we also need to look at risk and reduce them. The protection of personal data is a fundamental right. and also applies in the digital world. So the following principles shall apply. Digital technologies and business model must be aligned with fundamental rights and not other way around. The system of values should also apply in the international context, at least between democratically governed countries of this world. The current political situation shows us how vulnerable systems, structures, and technologies are to abuse. It also shows us once again that regimes and dictators do not refrain from violating human rights, but also use technical means to spread disinformation and track and prosecute people. Therefore, it's my personal wish that Germany and the United Kingdom will jointly advocate maintaining a fundamental rights and value-based legal system. And they will jointly stand up for ensuring a high level of data protection in the digital and global age. Thank you very much for your attention up to that point.
Thank you very much, Professor Kelber. I think that your introductory remarks gave a impressively both comprehensive but also succinct overview of a lot of the key issues that we're all grappling now in the area of data flows and particularly international governance. And of course, it makes absolute sense to focus on the development that was very much legal history for the EU in the issuing of the data adequacy decisions, both for the GDPR and under the Law Enforcement Directive, the Law Enforcement Directive adequacy decision for the UK being the first ever issued by the EU. So, as you mentioned before, this is one of those significant moments whereby you have this unique situation, former EU member state, now a third country. And I was wondering if perhaps you would be happy to explore more a statement you made earlier on regarding comments made by the former Minister for Digital in the UK with respect to how the UK's data protection framework may diverge from the EU acquis as it currently stands. And you made a very important point regarding future cooperation between the UK and Germany in terms of making sure that data protection frameworks are underpinned by a fundamental rights approach. So do any of the comments or do any of the publications by the UK government regarding proposals that would diverge from the current data protection framework, are there any specific changes that give you pause for concern?
The starting was in the very early stage of the Brexit process, with that idea of a European Singapore at the coast of the European Union, which gives the impression, not only in the area of data protection to Europeans, that there will be a race and picking of things where the standards which were established in the European Union will be lowered to give an advantage, in competitional advantage in prices for environment protection or data protection, things like that. That was the start, that this actual administration told that they will change standards which were achieved in the European Union to give to have an advantage in competition on the global standard. After these first announcements of the British Digital Minister that there will be a change in the British national laws, there was a process, and I see a paper one time with a number of points where they were thinking on changes. Most of them were not critical. 2 or 3 were even parts where say, hey, that would be a nice update to the GDPR itself for higher standards than today. But especially in the question of legitimate interests, which is an open point even in the GDPR, which are legitimate interests. There was an announcement that will be a change. So that's one thing on the real national law, which wouldn't be that problematic if British companies which process transferred data will follow the market principle of the European General Data Protection Regulation, as long that would be no problem if there is no transfer to a second, third state, which undermines this market principle of the GDPR, and as long as European United Kingdom security laws will not even be more disproportionate than in the past. And to be open, there are some European member countries, European Union member countries, which would have problems to get an adequacy decision if they were not member of the European Union. And we know that the UK security laws were even problematic as long as they were members. For example, sharing some informations from the common European databases with the US security enforcement authorities. So these are these different stages, these different areas where we have to monitor the development on the UK side, from the European side, to see if there's still an adequate level of data protection.
Thank you. So yes, there have been a number of documents that have put forward some proposals that, as you mentioned, could, of course, Ollie, nothing is black and white because we have no legislative proposal at the moment. These are all at the consultation stage, so to speak. But one of those proposals would be a fundamental change to the lawful grounds for legitimate interests, that there could be a new legal framework whereby the necessity to have a balancing test could be removed. And in terms of this being a more pro-business approach, there is an argument on the one side that this will assist in dealing with some of the ambiguity that surrounds some of the high-level principled approaches under the GDPR. But for critics of the approach, there's a concern that this will lead to a watering down of a fundamental rights-based approach to data protection by businesses, also within the public sector. And there's also some concern around proposed reforms to amend the substantive principle of fairness within the context of AI and automated decision-making. So, as you mentioned earlier on, we live in a very digitized world now. Following the pandemic, we are a connected space. This isn't a European or an EU issue. This is a global issue. So in terms of there being any changes to Article 22 of the GDPR with regard to safeguards and the prohibition for the use of automated decision-making, do you think that's something that requires a very careful approach, or do you think that's something that perhaps should be left alone entirely?
No, the first thing is to come back to the legitimate interest. It's an open wound in the GDPR itself, because a number of important cross-border cases which are about legitimate interest are not solved in the European Data Protection Board. So the real question, how far legitimate interest can reach inside the GDPR, is not really decided now, neither from the European Data Protection Board and the leading supervisory authority, nor from European courts. So this is even open, but this announcement, the proposal, the idea to even shift that balance to more possibilities for the processor side to show up legitimate interest and to water down these fundamental rights of the data subject is a very dangerous process. So that would be one idea of existing questions. And the other one is that there are new things to regulate. The idea of the not only of automatic decision making like in the GDPR, but a real world automatic decision making. So even if there are some human touch inside the process, when it's highly depending on automatic processing and maybe even change of the purposes of the data processing, the EU is looking up how to regulate this, and that would be a second topic for such international cooperation. Will have these AI regulation questions in our G7 roundtable too, because it was one of the 6 topics we started last year, and now 7 topics, 7 of us, and every authority is still working on the topic they brought in, and that's the idea of this trio of UK as the former presidency, us as the existing, and the Japanese as the coming presidency, to really have pragmatic and real-world proved proposals from the Data Protection Supervisory Authority side. To give a chance to see that on the long run, not trying to block international data transfer is the best chance for a high level of data protection, but really to promote the idea of an international agreement on a set of basic rules, especially for the government access first, and then to see for other purposes how to find standards to even give companies and other data processors a level playing field, one regulation as far as possible.
Thank you, Uli. So, as you mentioned before, these data adequacy decisions that were issued to the UK, they are, well, I really liked the use of your term. It is a situation of data adequacy decisions on probation because they've been subject to a sunset clause, which is unprecedented, even with the small number of data adequacy decisions that have been issued by the EU to third countries. Do you envisage the sunset clause being evoked in future decisions where there are some concerns regarding that particular third country continuing to meet this essentially equivalent test under EU law?
I'm absolutely sure that there will be sunset clauses to other decisions too. But to look at the Korean adequacy decision, there's no sunset clause. So the trust in the newly established Korean national law to stay on an adequate level was at that time higher than with the UK telling all the world that they will really run away some distance from the European Union level of data protection.
And in addition to the data adequacy decisions, they were clearly very welcome, no doubt, by businesses, the UK government, and also, of course, by businesses and the public sector across all EU member states, no doubt, including business and the public sector in Germany. Also, there's a considerable amount of data flows that happen every day between Germany and the UK, both within the public sector and private sector. But should there be any issues found by the European Commission within this 4-year period, it would not only jeopardize the data adequacy decisions as the key data transfer tool, but it could also jeopardize the key provisions of the trade and cooperation agreement, which also is the other framework underpinning other data transfers between the UK and the EU, and also the UK and Germany. So do you have any views on any particular provisions of the trade and cooperation agreement and how it speaks to the data adequacy decisions?
It would be better to ask someone from the European Commission on that, because we all know it's not only data protection that not for its own and adequacy decisions, but they are part of a political decisions made and of a political situation even between the European Union and UK, and all of this, what will happen will be interpreted in aspect of that scenario. What is the development of the connection between UK and the European Union? And but what I see is not my main idea as someone who is in charge of data protection is not to really, if there would be a watering down in the UK, to just shut down the adequacy decision or to cancel it. Because we know that regardless of the Brexit, UK and the European Union are so highly interconnected that both will suffer. On the first side, UK will suffer much more, but the European Union must not stay for its own, even if there are 450 million of us, not only 60. But we have to establish that possibility to have a free flow of data with trust. And it's such a nice name, with large economies worldwide. So the idea is not of giving up adequacy decisions, but to find a global agreement with a number of countries, and with the North American countries, with some of the outreaching countries of Latin America, of Asia, and to be open for the African countries on that part. And this is not only an important question of our own prosperity, but to give these other countries an alternative to the Chinese and Russian understanding of digitization. So it's we have that obligation to give an alternative in a alternative role model. And this obligation is to both sides, to the UK side and to the European Union side.
So it's really helpful that you've mentioned again the role of the GPA, the Global Privacy Assembly, and its various functions in terms of guiding international governance and data protection and privacy law, and the fact that it's worked very closely with the G7, particularly with the UK presidency last year, and now of course this being held by Germany. Do you envisage quite a productive set of developments specifically on data flows? It is highlighted in the programme, as you mentioned, that a focus on the development of data flows, and also the GPA mentioned this in their annual gathering last year, that this would be a key focus for an international framework for data flows. Do you have any concerns regarding how that will be achieved when it seems very much that the EU, and particularly the Court of Justice of the EU and some of its landmark data transfer judgments, particularly Schrems II, the Canadian Passenger Name Record Data Agreement, have particularly high and quite prescriptive standards, and the principles that the digital trade principles that emerged in October of last year, while quite helpful towards this path that you're talking about on international governance, a new global framework, they were quite high level, and they perhaps are a little uncertain on how closely they align themselves with the EU standards. So just to give a specific example, there is no mention, for instance, about independent oversight or independent supervisory oversight when it comes to government access, for instance, in the digital trade principles. And although one might say, well, that makes sense in the context of just digital trade, we know from EU law, of course, and you know incredibly well, that the private sector and the public sector government access issues are very much entwined in terms of the rule of law considerations under the GDPR. So how much further do you see in terms of detail emerging from the G7 digital trade principles on the question of government access and rule of law considerations?
If you have a look on the starting points of especially the European side and the North American side, then it's obvious that both decisions of the European Court of Justice limits the room to maneuver for the European side, because they really made clear that this is not a question of just national law giving and agreements made by the European Union Commission, but that some of that fundamental rights derives from the European Charter of Fundamental Rights, so cannot be changed by European law. That means this idea that European citizens must have the possibility for remedies, for example, is so fundamental that I have no idea, and I won't have idea, of how such an agreement can be made if European citizens still be billed citizens second class in a different, in a third country. So this is a place where especially Americans must know that they have to come one step closer to the Europeans. And I don't think that this is really a problem, not even on the security side, because I know that sometimes I find governmental access to data, especially these bulk queries to data, where I don't really see an empirical hint that this is really a plus for security. You know that most of this is confidential, but one number which is public is the German examinations of flight of passengers personal data. And if you see of how many data are collected, in how many data sets the AI finds something, and how many people you need to really test that findings and bring it to the next level, then sending it to security forces, then security forces to do something, and then the result, then you come to a 0.0000, I think, 0.13%. And that's so, and then it's not the result that that's a terrorist on its way to the next assassination, but maybe, for example, someone with found on a arrest list or something like that. So that's a ridiculous waste of resources. And to become a little bit more restrictive on that side, and then to get such an international agreement of free flow of data, just to look out on national data law, but being free to transfer that data. If you weigh the both things, then it's clear what is more important to the Western societies.
Thank you very much, Uli. So I have to say, I could spend all evening talking about some of the fascinating issues and themes that you've raised, but I must take a pause here because we have a few fascinating questions from the audience that I think is only fair if I direct them to you for your consideration. So to begin with, there are some very specific questions about your knowledge of certain individuals in Germany, which I will leave completely at your discretion. But we have some very interesting questions, legal governance questions from Benjamin Scrace. I hope I'm pronouncing that correctly, Benjamin. And he has a series of questions, but since we're limited to time, Benjamin, I'll just select one if I hope you're happy with that. And he would like to know whether you would consider that the UK can maintain high standards of data protection with a separate data protection regime that does not align exactly with the obligations of the EU GDPR? And if not, why not? So we've addressed some of those issues already, Uli, but is there anything more that you would like to say about that topic? I think it's a topic that's at the forefront of everyone's mind at this conversation point right now.
Absolutely, yes. It must be an adequate level. It must be not a copy of the European Union law.
Thank you. So there's another question from Sandra Leaton Gray, and she asks about the risk-based approach evident, in the Google Analytics position. So it seems here she might be referring to the CNIL Google decision recently. She's talking about the fact that the data is not high risk, and asks the question of, so if it appears that it is followed precisely, is it effectively to be an absolute prohibition on US transfers? So this seems to be a question that turns on the requirements of Schrems 2. And even though the CNIL decision regarding Google and Google Analytics isn't mentioned, it seems to be touching on that very significant development. Would you like to comment on that at all within the context of data flows and high standards?
Sure. There is no prohibition of data transfer to third countries. But there is the obligation for the processors and for the data protection supervisory authorities to examine in every single case if the adequate level of protecting this data is achieved. So there are some parts where the standard contractual clauses presented by the European Union are quite good enough for that. Then there will be parts where additional supplementary measures has to be taken. Taking one very simple one, if you store data on a US-based cloud service, just storing them, not more than that. And you encrypt that data on your side, storing it, taking it back, encrypt it, then this is no problem from the data protection side. That's a typical supplementary measure. But most of these days, cloud services give you the possibility to process that data in the cloud. And that means they are decrypted. But there are even technologies in preparation which work on encrypted data, never be encrypted in the way. So maybe technology will give some answers to. But it's important to know that other than on the inside European Union data protection, where a so-called risk-based approach is established, there is no risk-based approach on international data transfer. Out of two reasons. The very simple one, there is no base for that in the GDPR itself. In the Chapter 5, there is no risk-based approach. No risk-based approach about like, this data are no risky, you can transfer them. There is a risk-based approach if you really examine which supplementary measures would be taken to guarantee the adequacy level. But the second one is no one really knows which data are for interest of security forces. They not only take informations like I built a bomb. They really take a number of things to make profiles, to find, what was the English idiom for that? If something is similar, they have the same shape. No, things are always the same. I don't know if so they look out if you act or be somehow equal to one person they know in the past for being a criminal or being partners of criminals or terrorists. So I have that word on my tongue, but it's not here. So we don't know really in which data they are interested in. And so there can be no risk-based approach on that, as long as the government access is disproportionate.
Thank you. Yes, so the emphasis on a fundamental rights-based approach in Chapter 5 of the GDPR is quite well established, and also in the case law of the court. Just to clarify, Sandra mentioned that she was focusing on the Austrian court case, and yes, not the Google decision, which concerns transparency and information requirements. But I hope that your answer there addresses some of the questions that you had, Sandra. We have another question. This is dealing again with security and public safety measures from Professor Juliette Lodge. And she mentions that under the Prüm 2 proposals on facial recognition data exchanges being linked to driving licenses, she has concerns about how fundamental rights can be protected under these new proposals, and if so, how? So are there any thoughts you would like to share regarding these future reforms of the Prüm exchange system?
You really get me unprepared. I'm not familiar with the expression of Prüm 2. What's that?
I am.
Maybe I know the same thing on another name.
My understanding is that these concern proposals about the expansion of the Prüm data exchange system and how they could be extended to also include facial recognition images. So, you know, you have biometric images already, you have fingerprints, you've got palm prints, of course, and you have certain vehicle data registration data that can be exchanged. And the UK, of course, is also included because this is also provided for under Part 3 of the Trade and Cooperation Agreement. So this is very relevant to the UK and to Germany that exchange a lot of data under Prüm every day. So I think, you know, the question is referring to the development of Prüm and its shift towards facial recognition and probably other automated recognition in biometrics.
So the second adequacy decisions also give room to that things which happen under the Prüm regime. But I know that we are working a lot on that question of biometric recognitions, not only facial recognition, but other biometric recognitions too, and that will be part of the new European regulation being prepared with Data Act and other of the regulation stuff of the European Union. I'm not familiar with the state of play of the working groups of the EDPB on that. So I can't give you a real experience answer on that.
Thank you. So in case there are any more questions, we do have a few minutes left if anybody would like to raise any other related topics. There is a question here from Andres Quell regarding data security, if I'm understanding this question correctly, and the responsibilities on either side. Do you think, particularly with everything that's happening in current affairs at the moment, Ali, particularly with regard to the Ukraine situation and cybersecurity, do you envisage data security coming to the forefront of data flow governance and policy making in the foreseeable future?
We do now see how important it would have been to really establish a safe and cybersecurity established environment for at least the most critical infrastructure, but even for all companies and political decision making. And this lack of using the last 10 years to really hook up to a system where you're self-sovereign, where you establish safe mechanisms, where we really look at the trade-off between the interests of security authorities, like weakening encryption, weakening end-to-end encryption, things like that, is now crucial at the point where we should have a look at cyber attacks on the European side. So yes, everyone has to know that there is insecurity as long as you not really know what the hardware or the software or the services or the source code development kits you use are really being constructed of. So this is an important point, and that has what are the consequences out of that. You have to build robust services which not only rely on one infrastructure, and where the loss of data does not really be a problem because there's so bulk of data being accessed and being combined with other data. So having a more decentralized and systems with more than one legs walking on, then you can lower the risks. That is one idea, and I hope that there's a lessons learned from the side of that conflict in the Ukraine these days.
Thank you. We have a follow-up clarification, Ali, from Professor Juliette Lodge, and it regards the expansion of any future EU legislation, possibly the draft AI Act, but she doesn't mention this. What she does ask is if you could expand at all on what safeguards could be put in place for behavioral biometrics.
The idea of the working groups in the European Union, in the GPA, and in the International Working Group on Technology are all to really expand the understanding of biometrics. We have that biometrics, facial biometrics, fingertip biometrics, speak recognition, but in reality, biometrics go much further. So the telebiometrics of really identifying people, tracking people, has much more possibilities, but even to see certain behavioral aspects, several biological aspects, and then try to establish a probability of the behavior or the biological situation of a person. So this is sometimes it's a little bit like voodoo technology, like filming and listening to people in an assessment center, and in the end telling which such a probability they will have a depression, or they are a person with that or that weaknesses and strength. But we will find that some countries in the world, even the ideas of trying to identify gay people at borders from the way they look and from the way they behave. We find ideas of identifying employees of who is close of just changing the company he's working for because he changed his behavior. The ideas are so numberless, and there are so creative people finding new things, illegal things from my perspective, to do if they really bring in that creativity for the sake of the of society. We will have much more progress. But yes, it's a real big problem. I know that a number of working groups try to really expand our understanding of biometric recognition.
Thank you very much, Ili. I see that Antonio has returned, probably to wrap up this conversation. So I'll just quickly give my thanks to you and to all of the participants for their fascinating questions. And thanks again to Antonio for the invitation to be here. It's been a really insightful and really interesting conversation. And thanks so much to Professor Kelber again.
Thank you.
Not much to add, but also a big thank you on behalf of the BGA. It was a real pleasure to have you and to listen to these fascinating developments in the field of data and data protection. And thank you also to everyone for joining us, for asking your questions. We have several events coming up this month. For example, members have been invited to a Chatham House event on Germany's digital competitiveness tomorrow, which is a good follow-on to today's conversation. We also have an interview with the British Ambassador to Germany, Her Excellency Jill Gallard, coming up on the 24th of March. And we look forward to some of our in-person events as well, including our Parliamentary Day lunch on the 23rd of June with the MP David Lammy. So lots to look forward to. But in the meantime, may I say thank you very much again to our two speakers tonight. It was a great pleasure to have you, and look forward to revisiting the conversation in the recording online. Thank you.